automatically renews for successive periods unless proper notice to terminate is given by either party. It can be created expressly, like a month-to-month lease, or it can arise implicitly, like when a lease doesn't state a termination date, or, most commonly, when a tenant stays after a lease expires and the landlord accepts rent. That creates a holdover periodic tenancy. Third, tenancy at will. This tenancy has no fixed duration and doesn't renew periodically. It could be terminated by either the landlord or the tenant at any time, although the source notes that most jurisdictions require reasonable notice for termination to be effective. It often occurs when someone is given permission to occupy property without a formal lease or rent agreement.
And the last one.
Tenancy at sufferance. This describes the situation when a tenant holds over, remains in possession after their lawful lease term has expired, without the landlord's permission. This is the weakest form of tenancy. It lasts only until the landlord either evicts the tenant or decides to treat them as a trespasser, or, by accepting rent, the landlord creates a new periodic tenancy by operation of law.
The statute of frauds applies to leases as well.
Yes. A lease for a term longer than 1 year must be in writing to be enforceable. The writing must identify the parties, describe the property, state the duration of the lease, specify the rent, and be signed by the party against whom enforcement is sought. Oral leases for 1 year or less are generally enforceable.
Okay, types of tenancies sorted. What about the duties? What are the tenant's main responsibilities?
The most obvious is the duty to pay rent. This is excused only in specific circumstances, such as if the premises are destroyed, terminating the lease, or if the landlord commits a material breach, like an actual or constructive eviction.
And like other present interest holders, tenants have a duty to avoid waste.
Yes, tenants must not cause material damage to the property. This includes both permissive waste neglect, failing to make minor upkeep if required by the lease, and affirmative waste, actively damaging the property. The source emphasizes looking at whether the tenant's actions affect the property's value, not just minor wear and tear.
What about major repairs? Is that on the tenant?
Generally, no, especially in residential leases. The source points out that while non-residential leases might validly place extensive repair duties on the tenant, provisions in residential leases attempting to make the tenant responsible for significant repairs are often voided by courts or statute based on implied warranties like habitability. The tenant's duty in residential settings is typically just to notify the landlord of the need for repairs.
If a tenant breaches, like failing to pay rent, what can the landlord do?
Landlords have several remedies outlined in the source. The most common is to terminate the lease and file an eviction action, often called summary process or unlawful detainer, to regain possession. Leases often contain forfeiture clauses, allowing termination for non-payment. However, landlords in most states cannot accelerate future rent and recover the full lease amount upon a simple breach. They are typically limited to recovering unpaid back rent.
What if the tenant just leaves, abandons the property?
If a tenant abandons the property, the landlord has a choice. Accept the tenant's surrender, which terminates the lease and ends the tenant's liability for future rent, or reject the surrender and try to hold the tenant liable. However, in most states, a landlord who rejects surrender has a duty to mitigate damages by making reasonable efforts to find a replacement tenant. For a holdover tenant, that tenancy at sufferance, the landlord can either evict them or choose to bind them to a new periodic tenancy, usually month to month.
Now, the flip side, the landlord's duties. What can a tenant expect the landlord to provide or do?
There are several key implied duties for landlords. First, the duty to give possession. States differ here. The majority, or English rule, requires the landlord to deliver actual physical possession of the premises to the tenant on the first day of the lease. If a prior tenant is still there, the landlord is in breach. The minority, or American rule, only requires the landlord to deliver the legal right to possession. If a holdover tenant remains, the new tenant's remedy is against the holdover, not the landlord. If the landlord breaches this duty, the tenant can terminate the lease, refuse to pay rent, or sue for damages. Second, the duty to repair. As noted before, while not a common law duty, the source states that in most jurisdictions, a duty to repair is implied in residential leases, requiring the landlord to maintain the property's condition.
And the big one for renters.
The warranty of habitability, yes. This is a major implied warranty in most residential leases. The landlord promises that the premises are and will remain safe and suitable for human habitation. They must maintain the property to meet basic building and housing code standards and correct defects that substantially affect the tenant's health and safety.
So if the roof leaks, there's a severe pest problem, or crucial systems like heating or plumbing fail, that could violate the warranty of habitability.
Absolutely, if it's a substantial issue affecting health or safety and isn't caused by the tenant. If the landlord breaches this warranty, the tenant must usually notify the landlord and give them a reasonable opportunity to make the repairs. If the landlord fails, the tenant has various remedies without terminating the lease, such as withholding rent often into an escrow account, repairing the defect themselves, and deducting the cost from future rent repair and deduct, or using the breach as a defense in an eviction action.
What is the covenant of quiet enjoyment?
This covenant is implied in all leases, residential and commercial. It's the landlord's promise that they will not substantially interfere with the tenant's use and enjoyment of the leased premises. This includes direct interference by the landlord, interference by someone claiming a superior title that the landlord should have defended, and in some cases failing to control disturbances on common areas, or by other tenants if the landlord has the legal ability to do so.
And if the landlord's actions or inactions substantially interfere with the tenant's use?
That can constitute a constructive eviction. The source details the elements. The landlord breaches a duty, like failure to repair or violation of quiet enjoyment. The breach causes a substantial interference with the tenant's use and enjoyment. The tenant gives the landlord notice of the problem and a reasonable time to fix it. The landlord fails to cure, and the tenant vacates the premises within a reasonable time due to the problem.
So if the landlord makes the place unlivable through their breach, the tenant can essentially treat it as if they were evicted, stop paying rent, and leave. But the tenant must leave to claim constructive eviction.
Correct. If you stay, you haven't been constructively evicted and likely remain liable for rent.
The source also mentions retaliatory eviction.
This doctrine prevents a landlord from evicting a residential tenant in retaliation for the tenant exercising a legal right, such as complaining about housing code violations to authorities or participating in a tenants' union. If an eviction occurs shortly after the tenant engages in protected conduct, it's often presumed to be retaliatory and invalid.
Finally, on the tenant side, what happens if the tenant wants to transfer their interest to someone else? The source distinguishes between assignment and subletting.
This is a crucial distinction based on how much of the original lease term the tenant transfers. A tenant generally has the right to assign or sublet their interest unless the lease prohibits it. If the lease requires landlord consent but is silent on the standard for consent, states are split. The majority rule requires the landlord to act reasonably, have a commercially reasonable reason for denial. The minority rule allows arbitrary denial.
What's the difference in legal effect between an assignment and a sublease?
An assignment occurs when the tenant transfers their entire remaining lease term to the new person, the assignee. The assignee stepped into the shoes of the original tenant. The assignee is in privity of estate with the landlord, making them primarily liable to the landlord for rent and any lease covenants that run with the land.
So the landlord can sue the assignee directly for the rent.
Yes. However, the source is clear. The original tenant is not released from liability just by assigning the lease, unless the landlord specifically agrees to a novation, releasing the original tenant. The original tenant loses privity of estate, but remains in privity of contract with the landlord and is thus secondarily liable if the assignee defaults.
Okay, so the original tenant is still on the hook contractually.
Right. Now, a sublease occurs when the tenant transfers less than their entire remaining term. The original tenant retains some future interest in the property, even if it's just the right to re-enter when the sublease ends. The subleasee becomes the original tenant's tenant.
And what are the legal relationships in a sublease?
The sublease pays rent to the original tenant, the sublessor, and the original tenant continues to pay rent to the landlord under the original lease. Critically, the subleasee has neither privity of estate nor privity of contract with the landlord. The subleasee's obligations run to the original tenant, not the landlord, unless the subleasee expressly assumed covenants of the original lease. The original tenant remains fully liable to the landlord for all covenants in the original lease, maintaining both privity of estate and privity of contract with the landlord. The source's diagram is very helpful here.
Landlords can also transfer their interests, right? Sell the building.
Yes, the landlord can sell the property or assign their rights under the lease to a new owner without needing the tenant's consent, unless the lease prohibits it. The tenant then owes rent to the new landlord, the assignee landlord, and the new landlord is bound by the original lease covenants that run with the land. Like the tenant scenario, the original landlord generally remains liable to the tenant for their promises in the lease unless the tenant agrees to release them.
That's a really thorough picture of landlord-tenant law. Understanding these rights and duties, especially around habitability, quiet enjoyment, and how assigning subletting impacts liability, while it's crucial for anyone involved in a rental agreement.
It clarifies the legal boundaries of that relationship.
Let's move on to the process of buying and selling land. The land sales contract and the closing.
Buying or selling property starts with a binding contract, which is a specialized type of contract with unique requirements due to the nature of the asset. Like any contract, it needs offer, acceptance, and consideration.
And the big hurdle for land is the statute of frauds. It applies here, requiring a writing.
Absolutely. The source states that a contract for the sale of an interest in real property must be in writing, signed by the party against whom enforcement is sought, and contain all essential terms,
Right.
identifying the parties, describing the property with reasonable certainty, and stating the purchase price.
What if there's no writing? Are there exceptions to the statute of frauds that courts might apply?
Yes. Courts recognize exceptions to avoid unfairness when there is clear evidence of an agreement despite the lack of a formal writing. The most common is part performance. If the buyer's actions demonstrate reliance on an oral contract, a court might enforce it. Most states require at least two of the following three actions by the buyer as evidence: taking possession of the property, making significant improvements to the property, and paying all or part of the purchase price. These actions make it highly probable that a contract existed.
Okay. Any others?
Yes. Also, full performance. If the seller has already delivered the deed, they can enforce the buyer's oral promise to pay. Detrimental reliance. If a party significantly relies on the contract to their detriment and would suffer hardship if it's not enforced. And admission. If the party being sued admits in court that the contract existed.
So while a handshake deal is legally risky, courts might still enforce it in specific situations where there's compelling evidence of the agreement and reliance. Once the contract is signed, what happens during that period before the closing?
This interim period is important. The contract contains several implied promises. One of the most significant is the seller's implied covenant to deliver marketable title at the closing.
Marketable title? What exactly does that promise mean for the buyer?
The source defines marketable title as title that is reasonably free from defects and would be accepted by a reasonably prudent buyer because it does not expose them to an unreasonable risk of litigation. It must show the seller actually owns the interest they claim and that there aren't hidden problems. The source lists common issues that make title unmarketable: undisclosed lines, mortgages, easements, covenants, significant encroachments, gaps in the chain of title, unreleased dower or homestead rights, and existing zoning violations or adverse possession claims. Those are the red flags.
So the seller isn't just promising to give a deed, they're promising to give a deed for property with a clean title by the closing date. If they can't, the buyer has remedies before closing.
Correct. If the seller's title is not marketable at the agreed-upon closing date, and the buyer hasn't waived the defect, the buyer can rescind the contract and get their deposit back, sue the seller for breach of contract damages, or seek specific performance if the defect is minor enough that the court might order the seller to fix it and proceed.
Does the closing date itself have to be met precisely, or is there flexibility?
The source notes that time is of the essence in a real estate contract, only if the contract language expressly states it or if the circumstances clearly imply it, like buying property for a specific event happening on that date. If time is not of the essence, a party's delay in closing is a breach, but it doesn't automatically allow the other party to cancel the contract. The non-delaying party can still enforce the contract, close late, and sue for damages caused by the delay.
What about the condition of the physical property itself? Is the seller obligated to disclose defects they know about?
Yes. For the sale of existing residences, the seller generally has a duty to disclose all known material physical defects to the buyer, unless the defects are readily observable by a reasonable inspection. A defect is material if it significantly affects the value or desirability of the property or the health and safety of occupants. The seller can't actively conceal defects.
And for brand new homes, is there any protection against hidden construction flaws?
Yes, the sale of newly constructed homes typically includes an implied warranty of fitness or suitability. This protects the buyer against latent construction defects that weren't apparent at the time of sale but surfaced later due to poor workmanship or materials. A lawsuit must be brought within a reasonable time of discovering the defect. While this warranty can be disclaimed or waived, it requires clear and unambiguous language in the contract. A general as-is clause is usually not enough.
So buyers have some legal recourse regarding defects, depending on whether the home is new or existing. What happens at the closing itself?
Closing is the culmination of the contract. The buyer pays the purchase price, often through financing from a mortgage, and the seller delivers the deed, legally transferring title. The source highlights the merger doctrine, which becomes effective at closing.
Merger, like the contract merges into the deed.
Exactly. The merger doctrine states that once the deed is delivered and accepted at closing, the land sale contract is considered performed and its terms generally merge into the deed. After closing, the rights and obligations of the parties regarding the title and condition of the property are governed primarily by the deed, not the contract.
Wow. So if the contract had a promise that wasn't also included in the deed, that promise might not be enforceable after closing.
Potentially. If a promise in the contract is collateral to the conveyance itself, like a promise to build a fence after closing, or explicitly states it survives closing, it might remain enforceable. But promises related directly to the title or physical condition, if not included as covenants in the deed or otherwise stated to survive, are often extinguished by merger. This emphasizes the importance of the deed's content. The buyer's recourse after closing for title issues must be based on the covenants of title contained in the deed.
What remedies are available if a party breaches the contract before closing?
The non-breaching party can seek damages. The standard measure is the difference between the contract price and the market value of the property on the date of the breach, plus any foreseeable incidental costs. The source mentions a minority rule where if the seller breaches due to a good faith inability to deliver marketable title, the buyer's damages might be limited to their out-of-pocket expenses, like title search costs, deposit, rather than the full expectation damages. If the buyer breaches, the seller can often keep the earnest money deposit as liquidated damages, provided the amount is reasonable. Courts often scrutinize amounts over 10% of the price.
Can they force the sale?
Yes, both parties can also generally seek specific performance, which is a court order forcing the breaching party to perform the contract as written. Because each parcel of land is considered unique, specific performance is almost always available to a buyer. A seller can also seek specific performance. Although some courts are more hesitant, since the seller's harm, not getting the money, might be seen as adequately remedied by monetary damages.
The source mentions equitable conversion applying during the contract period. What does that doctrine mean?
Equitable conversion is a doctrine used in equity that views the buyer as holding equitable title to the property once the contract is signed. The seller holds legal title, but holds it essentially in trust for the buyer, with a right to the purchase money. The primary consequence noted in the source is that, under this doctrine, the buyer typically bears the risk of loss to the property, like damage from fire or natural disaster that occurs between the signing of the contract and the closing, unless the contract specifies otherwise or the loss was due to the seller's negligence.
That is a major risk for buyers. It highlights why getting insurance effective from the contract date is crucial.
Absolutely. It's a significant legal shift of risk.
Finally, the source briefly touches on options and rights of first refusal related to land sales.
An option contract gives a potential buyer the exclusive right, for a specified period, and usually for separate consideration, to purchase the property at a set price. It's a right to buy, not an obligation. A right of first refusal means that if the owner decides to sell the property, they must first offer it to the holder of the right, usually on the same terms offered by any third party. Both create interest in land and must comply with the statute of frauds, requiring a writing.
The land sales contract and closing process is clearly filled with potential legal pitfalls and crucial moments like the duty to disclose, marketable title, equitable conversion, and the merger doctrine.
It's a tightly regulated transaction designed to ensure clarity and protect both parties, but requiring careful attention to detail.
And buying land usually involves borrowing money, bringing us to mortgages and other security devices.
A mortgage is a legal mechanism where an interest in real property is used as security for the repayment of a debt. The borrower is the mortgager, who grants the security interest in their property. The lender is the mortgagee, who holds the security interest. Like other interests in land, mortgages must be in writing to satisfy the statute of frauds.
We saw how lien theory versus title theory states can affect joint tenancies. Does this distinction generally impact mortgages?
It reflects a fundamental difference in how the mortgage relationship is legally framed, although the practical effects are often similar today. In lien theory states, the vast majority, the mortgager, the borrower, retains legal title to the property, and the mortgagee, the lender, holds only a lien and security interest on the property. The borrower keeps possession and ownership rights. In title theory states, a minority, the traditional view is that the mortgagor technically conveys legal title to the mortgagee until the debt is paid off, although the mortgagor usually retains possession and the right to regain title upon full payment, the right of redemption.
So the main practical difference might be related to the lender's right to possess the property before foreclosure.
Yes. In lien theory states, the lender generally cannot take possession before foreclosure. In title theory states, the theoretical right to possession might exist earlier, though mortgage agreements often delay this right until the borrower defaults. Regardless of theory, if a lender does take possession before foreclosure, they are obligated to manage the property prudently and not commit waste.
The source mentions alternatives to standard mortgages, like deeds of trust and installment land contracts.
A deed of trust is a very common financing instrument used in many states instead of a traditional mortgage. It involves three parties: the borrower, who conveys the property; the lender, the beneficiary of the security interest; and a neutral third-party trustee, who holds the deed as security for the lender. If the borrower defaults, the lender instructs the trustee to sell the property through a non-judicial foreclosure process, often called a power of sale foreclosure. Functionally, for most purposes, deeds of trust are treated similarly to mortgages. An installment land contract, or contract for deed, is where the buyer makes periodic payments to the seller, gets immediate possession, but the seller retains legal title until the entire purchase price is paid. If the buyer defaults, the contract often allows the seller to declare the contract forfeited, keep all payments made, and reclaim the property, which can be very harsh on the buyer. Many states now offer some protections to defaulting buyers in these contracts, requiring a process similar to foreclosure or allowing the buyer to recover some of their investment.
That seems much riskier for a buyer than a standard mortgage where the buyer gets the deed at closing.
It can be, which is why those statutory or judicial protections have emerged. The source also briefly mentions that courts might treat other arrangements, like absolute deeds given as security or conditional sales with a right to repurchase, as equitable mortgages, if the true intent was to create a security interest for a debt.
What happens if a property with a mortgage is transferred to a new owner? Does the original borrower still owe the money?
The source is clear. Transferring mortgaged property does not automatically relieve the original borrower of liability for the debt, unless the lender expressly releases them a novation. The new owner's liability to the lender depends on how they take the property, as the source illustrates.
They can take it subject to the mortgage or they can assume the mortgage.
Correct. If the new owner takes the property subject to the mortgage, they are not personally liable to the lender for the debt. They haven't made a promise to the lender to pay. However, the property itself remains subject to the mortgage. If the mortgage payments aren't made, the lender can still foreclose on the property and the new owner will lose it. But the lender cannot sue the new owner personally for any deficiency if the sale proceeds are insufficient.
Okay.
If the new owner assumes the mortgage, they expressly agree to pay the mortgage debt. The source states they become primarily liable to the lender. The original borrower then becomes secondarily liable as a surety. The lender can pursue the original borrower if the new owner defaults and the foreclosure sale doesn't cover the debt.
So if you assume the mortgage, the bank can come after you personally for the debt. If you take subject to her, they can only take the house, not sue you personally.
That's the key difference in personal liability. However, the source notes that most modern mortgages contain a due-on-sale clause. This clause gives the lender the option to demand that the entire loan balance be paid immediately if the property is transferred. This effectively prevents buyers from simply taking over the existing loan, either subject to or by assumption, without getting the lender's explicit consent, which often involve the buyer having to qualify and potentially refinance at current interest rates.
What rights does the borrower have before foreclosure to stop it?
The most important is the equitable right of redemption. This right is recognized in all states and allows the borrower to prevent a foreclosure sale after defaulting but before the sale actually occurs. To exercise it, the borrower must pay the full amount of the debt currently due, which typically includes any missed payments, accrued interest, costs, and if there's an acceleration clause, which is common in mortgages, the entire remaining principal balance of the loan.
Paying the whole loan just to stop a foreclosure, that can be a huge barrier.
It can be, especially if the lender has accelerated the debt. The source also mentions that some states provide a statutory right of redemption. This right, where it exists, allows the borrower, and sometimes other junior lien holders, to redeem the property after the foreclosure sale has taken place, for a period defined by state law, like 6 months or a year. To exercise this, the party redeeming typically must pay the foreclosure sale price, not necessarily the original full loan balance plus cost to the buyer at the foreclosure sale.
And a deed in lieu of foreclosure is a non-foreclosure option.
Yes, it's a voluntary arrangement where the borrower conveys title to the property directly to the lender in exchange for the lender releasing the borrower from the mortgage debt. It avoids the foreclosure process, can be less damaging to the borrower's credit than a full foreclosure, but the borrower does lose the property.
If default isn't cured, it leads to foreclosure.
Foreclosure is the legal process by which the security interest in the mortgage or deed of trust is enforced, usually by selling the property to satisfy the outstanding debt. The source states that a lender can initiate foreclosure upon a material default, such as non-payment. Proper notice to the borrower is required. As mentioned, if the loan have an acceleration clause, the full balance becomes due, and the foreclosure aims to recover that amount.
How do foreclosure sales actually happen?
The source outlines the main methods. First, judicially supervised public sale. Available in all states, this requires the lender to file a lawsuit and the sale is conducted under court order and supervision. It's a slower, more formal process. Second, privately conducted sale, power of sale. Allowed in more than half of states, typically if the mortgage or deed of trust includes a specific power of sale clause. This process does not require court supervision, though strict notice requirements apply, making it faster and cheaper for the lender. This is common with deeds of trust. And third, strict foreclosure. Permitted in very few states, this allows the lender to take title to the property directly upon default, without a sale. The debt is extinguished, and the borrower loses the property but owes no deficiency.
When a foreclosure happens, what happens to other debts or claims against the property? This involves priority of interests.
This is a critical outcome of foreclosure. A valid foreclosure action generally extinguishes or wipes out all interests in the property that are junior lower in priority to the mortgage being foreclosed. These junior lien holders get paid out of the sale proceeds only after the foreclosing lender is fully satisfied. However, the foreclosure does not affect interests that are senior higher in priority to the foreclosing mortgage. The buyer at the foreclosure sale takes the property free of the junior liens, but takes it subject to any senior liens that still exist. Those senior liens remain attached to the property, and the new owner will be responsible for paying them to avoid a future foreclosure by the senior lender.
So priority determines who gets paid and whose